Question 291. The most common type of lease agreement lasts for a specific period, such as month to month or year to year. This agreement is called a life estate, b. periodic tenancy, c. estate at sufferance, d. tenancy at will. Correct answer is B. periodic tenancy. A life estate is related to real property ownership, not leasing. It grants someone the right to occupy a property for their lifetime or the lifetime of another designated person. An estate at sufferance, also known as tenancy at sufferance or holdover tenancy, is a legal term that describes a tenant who continues to occupy a rental property after their lease has expired. The tenant is also known as a holdover tenant. A tenancy at will is a lease agreement with no fixed term. It can be terminated by either landlord or tenant at any time, usually with proper notice. Periodic tenancy automatically renews for the same period, month to month, year to year, unless either party provides notice to terminate the lease before the end of the current period. This is the most common type of lease agreement for residential rentals. Question 292. Andy promises to paint Sandy's house if Sandy will promise to drive Andy and his dog to Canada. If Sandy makes that promise in return, it would qualify as a consideration, b. an option, c. a pledged promise, d. all of the above. Correct answer is a consideration. Consideration, an element of a binding contract, does not have to be in the form of money. It may consist of a promise to perform a desired act or a promise to refrain from doing an act. In a bilateral contract such as this one between Sandy and Andy's dog, an agreement by which both parties exchange mutual promises, each promise is regarded as sufficient consideration for the other. Question 293. A court would likely find fraud had been committed if a. an unintentional mistake by the seller persuades the buyer to purchase a property, b. the buyer purchases property based on the seller's lie, c. the seller's agent informs the buyer if he does not go ahead with the purchase the agent will ruin the buyer's business, d. all of the above. Correct answer is b. the buyer purchases property based on the seller's lie. To establish fraud, several elements generally need to be proven. Misrepresentation of a material fact. The seller made a false statement about a significant aspect of the property. Knowledge of falsity, scienter. The seller knew the statement was false or made it with reckless disregard for its truth. Intent to induce reliance. The seller intended for the buyer to rely on the false statement. Actual reliance. The buyer actually and justifiably relied on the false statement. Damages. The buyer suffered harm as a result of the reliance. Let's analyze each option. A. An unintentional mistake by the seller persuades the buyer to purchase a property. This scenario likely constitutes a negligent misrepresentation or an innocent misrepresentation, but not necessarily intentional fraud. Fraud requires intent to deceive. B. The buyer purchases property based on the seller's lie. This scenario directly meets the elements of fraud. A false statement, lie, made by the seller with the intent that the buyer rely on it, and the buyer does rely on it, potentially suffering damages. C. The seller's agent informs the buyer if he does not go ahead with the purchase the agent will ruin the buyer's business. This scenario describes duress or undue influence, where the buyer's decision is coerced through threats. While it can make a contract voidable, it's legally distinct from fraud, which involves deception. Therefore, intentional deception by the seller that the buyer relies upon to their detriment is the key element for a finding of fraud, b. Therefore, intentional deception by the seller that the buyer relies upon to their detriment is the key element for a finding of fraud, b. Question 294. During the loan term, the lender may ask the borrower to make regular payments towards the recurring costs. These payments are deposited into an A. Impound account, B. Custodial account, C. Reserve account, D. Both A and C. Correct answer is D. Both A and C. Impound account is the most common term used in the real estate and mortgage industry to describe an account held by the lender to pay for recurring property-related expenses like property taxes and homeowners insurance. The borrower makes regular payments into this account along with their principal and interest payments. Reserve account is also used interchangeably with impound account in many contexts, especially when referring to the funds held by the lender for future payments of taxes and insurance. While a lender holds the funds, the term custodial account is less commonly used in this specific context of mortgage servicing for taxes and insurance. It's a broader term that could apply to various situations where one party holds assets for another. Therefore, both impound account and reserve account accurately describe the account where a lender holds funds for the borrower's recurring property costs. Question 295. Brian, a potential buyer, offered to purchase the home of Oscar, the owner, sending a written offer to Oscar's listing broker. Oscar decided to accept the offer, while changing the amount of the good faith deposit from $10,000 to $15,000 by writing in the higher number on the offer form. He then communicated his acceptance of the offer by signing it and sending it back to the broker, who properly notified Brian, the buyer. The acceptance of the offer is A. Binding upon Brian because Oscar only changed one of the terms, B. Binding upon Oscar since he signed the offer, C. Binding upon Brian, but for the original deposit amount, D. Non-binding upon any of the parties. Correct answer is D. Non-binding upon any of the parties. Once a party changes a term of the offer, it automatically terminates while a counter-offer is created. Brian's silence doesn't imply acceptance, unless Brian explicitly agrees to the new deposit amount. His silence doesn't automatically bind him to the counter-offer. In this scenario, neither the original offer nor the counter-offer has been definitively accepted. Here's how the situation might unfold. Brian could choose to accept Oscar's counter-offer with the higher deposit amount. Brian could propose a new offer with a different deposit amount or other changes. The negotiation could continue until they reach a mutually agreeable offer, or both parties could walk away. It's important for both parties to clearly communicate their intentions to avoid any misunderstandings or disputes during the offer and acceptance stage of a real estate transaction. Question 296. By executing a power of attorney document, a party conveys legal authority to a representative designated to make property, financial and other legal decisions on the party's behalf. The party's representative is called an A. Quasi-attorney, B. Special agent, C. Fiduciary, D. Attorney in fact. Correct answer is D. Attorney in fact. The power of attorney will terminate upon the incapacity of the party making the assignment, unless it contains a durability clause. An attorney in fact, also known as an agent, is someone who is legally authorized to act on behalf of another person in real estate transactions. The person who appoints the attorney in fact is called the principal. The attorney in fact doesn't need to be a lawyer, and can perform a wide range of personal and financial functions. Question 297. Every month for the last 5 years, a broker collects the rent for apartment units on behalf of the building's owner. On January 31st, the owner suddenly dies. The next day, when the agent makes his regular trip to collect the monthly rents, one of the apartment tenants refuses to pay the broker on the grounds that the owner's death had automatically revoked the existing agency between the owner and the broker. Is the tenant legally justified in withholding rent? A. Yes, the tenant is correct. B. No, the broker has the right to continue collecting the rent as long as he deposits the funds in an escrow account administered by the owner's heirs. C. No, the broker has the right to collect the rent until the owner's will is made public. D. A judge will need to decide the issue. Correct answer is A. Yes, the tenant is correct. In agency law, the death of the principal, the property owner in this case, automatically terminates the agency relationship by operation of law. This occurs immediately upon the owner's death, regardless of whether the agent or third parties, like the tenants, are aware of it. Once the principal dies, the broker no longer has the legal authority to act on their behalf, including collecting rent. The tenant's obligation to pay rent still exists, but it is now owed to the deceased owner's estate, their heirs or the executor of their will. Paying the former agent after the principal's death would not necessarily discharge the tenant's rental obligation to the rightful recipients of the funds. Therefore, the tenant is legally justified in refusing to pay the broker because the broker's agency was automatically terminated by the owner's death. Question 298. A broker can pay a portion of his commission to the buyer, if the broker A. informs the real estate commissioner, B. informs the seller, C. does not pay the seller more than half his total commission, D. it is illegal for the agent to pay any portion of his commission to the buyer. Correct answer is B. informs the seller. While there might be specific regulations depending on the jurisdiction, in most cases, a broker can share a portion of their commission with the buyer as long as they inform the seller and obtain the seller's consent. Transparency is crucial. The seller has the right to know how much commission is being paid and how it's being divided. The seller needs to agree to the commission split with the buyer. Question 299. A legal document that requires a borrower to pay a particular interest rate during a certain period of time is called A. trust deed, B. bond, C. note, D. certificate of deposit. Correct answer is C. note. A trust deed is used instead of a mortgage to secure a loan on real property. It involves a third party, trustee, holding the title until the loan is repaid. A bond is a debt security issued by governments or corporations, promising to repay a principal amount plus interest over a specific time. Certificate of deposit, CD, is a bank account that offers a fixed interest rate for a specific term. A note, short for promissory note, is a legal document that outlines the terms of a loan, including the principal amount, interest rate, repayment schedule, and borrower's obligations. Question 300. All of the following statements about an attorney in fact are true, except A. One who is legally authorized to act on someone else's behalf, B. a fiduciary, C. they must be an actual attorney, D. an agent. Correct answer is C. they must be an actual attorney. An attorney in fact is simply someone who has been granted the legal authority to act on behalf of another person, the principal, through a power of attorney. The person appointed as attorney in fact does not need to be a licensed attorney. Any competent adult can be appointed as an attorney in fact, as long as they are not disqualified by the power of attorney document or state law. They can be a family member, friend, business associate, or anyone the principal trusts to handle their affairs. In order to be designated as someone's attorney in fact, the principal must sign a power of attorney form. Other true statements. A. One who is legally authorized to act on someone else's behalf. This is the core definition of an attorney in fact. B. A fiduciary. An attorney in fact acts in a fiduciary capacity, meaning they have a legal and ethical obligation to act in the principal's best interests, with loyalty, honesty, and good faith. D. An agent. An attorney in fact is a type of agent, acting under the authority granted by the principal. Therefore, the key distinction is that the term, attorney in fact, refers to the authority granted, not necessarily to the profession of the person holding that authority.